Heyo, good morning in the United States. Apologies for my voice. I am recovering from a man cold. And but that will not stop me from streaming this verdict. Even if my voice goes out, still going to show the verdict. We have a few minutes before the judge announced he will start reading it, but you have seen the trial coverage, know that uh, he's been late every day by 10-15 minutes, but I sincerely hope he will not be late today. As you can see, I changed my background. And that is because I do not want Henry Dinkins' face in my background. And I learned that Breasia liked seashells. So, seashells it is. And welcome everybody. I see you are all starting to gather here. I put up a poll, English pronunciations, on what you think the judge will decide. Not what you hope, but what he will decide. So please take that poll, and we will present that later on. You who have followed me know where I stand in this. Do I believe Mr. Dinkins did it? Yes. Do I believe the prosecution proved it? I'm not too sure, because in my opinion, and this might be the difference between me and my law degree and you normals, my standard of beyond reasonable doubt is a bit higher than the average person. So that might be the difference. And you who have followed my coverage of this, you have seen me yell at the prosecution. You have, because in my opinion, Breasia deserves better. In my opinion, but the defense presented their case. The prosecution, the defense, there were closing arguments, and then they left it to the judge. What is it? 2.5 weeks ago. And then on Friday last week, he announced, I will read the verdict next Friday, which is today. Now, why did he announce it so far ahead? Well, scheduling. And it's because he's a judge. He has more trials, more hearings. He's a busy guy. And then he has to schedule so defense can be there, prosecution can be there, the families can be there. Well, Mr. Dinkins really don't need a schedule. He just have to be there. And so that is where we are. I am currently having there are two channels. Let's see here. And it hasn't started yet. Yes, I have two sources. If one doesn't cut it, I have another to spare. So we will stream the verdict. I'm also streaming this on YouTube, on Rumble. So if you really want to go spicy, you can go to my Rumble channel. I will ask a mod to post the link to my Rumble channel. That chat is you can get a lot more spicy on. YouTube, not so much, because I know I am Swedish, and our laws are a bit different. Since I'm considered a publisher in Sweden, I have legal responsibility over commentary, even in the chat. So I really can't allow it to be too spicy. But on a Rumble, you go right ahead. And I see here that my internet is fluctuating, but it shouldn't be an issue. We are having, apparently, I learned this in Jeff's over at Legal Vices, that there is a small solar flare going on. So that affects people's internet and Wi-Fi all over the world. And US East Coast also happens to have somewhat of a hurricane. So there's a lot of things that might affect this, but we will try our very best. I am continuously checking here so we don't miss anything. Let's see who's here. Marida Finn, Daily Quick Bites. Gigi is my moderator. Yeah, okay. That I will pin my Rumble channel on the top of the chat. So you can follow me there as well. Now, you don't need an account on Rumble to watch it, but if you want to comment, you need to have an account. But yeah, Wolfram is here, Melissa, keeping it real, Corn Pope, hi Corn Pope, Peace Peony, and I recognize you from my streams about this, and a bunch of other people. Please let me know if, as long as I have sound, this face being blurry, I don't think it will matter. It will matter as long as we have sound. All right, let's see. Refreshing my two sources to see if anything is happening. Nope, they are still on standby and waiting for the court feed them as well. See, Sauder is here. Hi. Willona is here. Erin is here. Let's just start while we wait with where are you all tuning in from? As you know, Swedish. I'm a union rep. I do labor law, which puts me in more of one of the wokest place on earth and the wokest occupation. I don't consider myself that, but that's not up to me to decide. And I still thank you all, either who tune in now, a live stream, or tuning in later at the replay. Thank you all for choosing me as your source for this. It's been an honor to try to guide us all through this procedure. And now if there are a few choices for the judge. Well, first of all, he can choose to have guilty on both counts. Guilty of kidnapping, not murder. I don't think he can go the other way around, or not guilty. And if he chooses guilty in either both or one account, or one or both of the charges, then he needs to motivate it. Well, he still needs to do that on a not guilty as well. And that will be really interesting for me to hear the motivation, because as you know, I'm not entirely sure their prosecution did the best job, in my opinion. So I really want to hear his opinion and his motivations, because if he finds a verdict, then he needs to motivate it so he doesn't leave appellate issues. So that is what I am expecting. And we don't know if he say that he goes to, let's see here. We have a feed up, but nothing yet. I will just leave it like this so we all see it. Hold on while I Nope, not that one. No, not that one. That one, definitely not. That one, nope, definitely not. Let's go with that one and that one. Yeah. All right. So we are, at least now, we have the stream up. Where was I? Yes. And I have a bit of a static, but that is from the stream. That's not from me. Yeah. If he chooses to go with guilty on one or both charges, then he motivates it. If he goes directly to sentencing, then you also have the victim impact statements. My mic goes wonky occasionally. Yeah, I've heard that before. Testing, testing. Yeah. For now, I really can't do much about it, but now I have a stream up. I will close down a bunch of things here. Let's see if it improves, because of that, I'm having my activity done in thumb soon too, so I can close down features to get. Yeah, yeah. It is what it is. Isn't the solar flare hitting 17th? Once the solar flare is off the sun, it is here. I'm not an astrophysicist, but on the way here, it presses a shockwave in front of it. Then you get the bigger hit. So I'm not sure. I'm not sure. On Jeff's stream on Legal Vices, they had issues, big issues. Hi, Sal, by the way. Yeah, and if the judge goes directly to sentencing, it's victims' impact statements and also statements for Mr. Dinkins. I don't think there will be that many people speaking on his behalf, but you never know. So we might be here for a good bunch of hours. Good bunch of hours. Hi, MG Law. MG Law, if you're available, I can send you a link so you can help out in doing this and explain what's going on to people. So just say so, and I will send you a link so you can help out. Yeah. So this might be just a reading of the verdict and the motivation, which still takes some time. If the judge chooses to do sentencing on a later date, I will stream that too, because I'm going to follow this trial to the very end. And yeah, you who tuned in yesterday know that I covered the Henry Dinkins letter, and which was really interesting because that letter indicates that he is given up. He thinks he will be guilty, found guilty, and he was he. My speculation is that he tried to run it by his lawyers, but they said, "What you are trying to say here, we can't send until after the verdict. You have to wait for the verdict." But Mr. Dinkins didn't listen, so he sent it in anyway. But the court did what the court did. They said to him, "You have lawyer. We don't care what you say. Use the proper channels." And I know that there are still a bunch of people watching that. Now you're tuning in here instead. That's good. I posted on Text from office, and they know I told them at the office that 3 p.m. my time, I'm out. I'm unreachable. Okay, here we go. It seems they are bringing Mr. Dinkins in. My stream is delayed. Yeah, it's Sweden. Oh, there. Pressing live on that. Yeah, I know the stream is a bit delayed. That's a YouTube thing. So it has a maybe 10-15 second delay. I can't do anything about that. The judge is in. I still have static, like... there's no sound from the court yet. Let's see if...
With the respect of the court.
I'm changing.
And I can't tell you how much I appreciate it. But I will not tolerate any outbursts as I read this decision. If there's anyone from any of the courtrooms within the courthouse today that do not conduct themselves appropriately, I have instructed the bailiffs and the law personnel present to remove those individuals. I know many have questioned why I did not make a decision immediately. And so I thought it was really important that I explain that to everyone. Under Iowa law, the court in a bench trial is required to write a written ruling in a bench trial and come into open court like I am today to read that verdict. I could simply read the verdict and file my written decision. I've chosen not to do that today. I think this case, due to the crime involved, is very important and very, I find that it's appropriate that I read the entire decision today.
Here we go.
Mr. Dinkins is charged in a two-count trial information with the crimes of murder in the first degree in violation of Iowa Code Section 707.2 under count 1 and kidnapping first degree in violation of Iowa Code Section 710.2 under count 2. Murder in the first degree is defined as a person commits murder in the first degree when the person willfully, deliberately, and with premeditation kills another person. Murder in the first degree is a Class A felony. Kidnapping is defined, itself is defined, as when a person either confines a person or removes a person from one place to another. Knowing the person who confines or removes the person has neither the authority nor consent of the other person to do so. Kidnapping first degree is defined as the act of kidnapping accompanied with the intent to inflict serious injury upon such person.
Oh, don't be buffering. I am buffered. I am buffered.
Or subject the person to sexual abuse. Kidnapping first degree is a Class A felony. The defendant is presumed innocent and not guilty. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. The defendant has entered pleas of not guilty, which is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. If the state has not proven the defendant guilty beyond a reasonable doubt, then the court must find the defendant not guilty. In considering the evidence presented, the court makes deductions and reaches conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. The court must decide the facts from the evidence. The court considers the evidence using its observations, common sense, and experience. The court will try to reconcile any conflicts in the evidence, but if the court cannot, the court accepts the evidence it finds more believable. In determining the facts, the court may have to decide what testimony to believe. The court may believe all, part, or none of any witness's testimony. In determining what testimony to believe, the court considers the reasonableness and consistency of the testimony with other evidence, and internally, whether a witness has made inconsistent statements, as well as the witness's appearance, conduct, age, intelligence, memory, knowledge of the facts, interest in the trial, motive, candor, bias, and prejudice. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of the evidence produced by the state. If the court, after a full and fair consideration of the evidence, is firmly convinced of the defendant's guilt, then there is no reasonable doubt and the defendant should be found guilty. But if after a full and fair consideration of all the evidence in the case, or from the lack or failure of the evidence produced by the state, the court is not firmly convinced of the defendant's guilt, then there is reasonable doubt and the defendant should be found not guilty. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily. Not by mistake or accident, the court may, but is not required to, conclude a person intends the natural results of his acts. Specific intent means not only being aware of an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires the court to decide what the defendant was thinking when an act was done. It is seldom capable of direct proof. Intent may be shown by circumstantial evidence and the reasonable inference drawn from the evidence. Therefore, the court should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. Facts. On July 10th of 2020, Breasia Terrell was reported missing. It was not until March 22nd, 2021, that she was found. On that date, her remains were found in Clinton County, Iowa, near a pond south of the Kunow implement dealership. Prior to her disappearance and death, Breasia knew the defendant, Henry Dinkins. Her mother, Aisha Langford, had a relationship with the defendant, and as a result of that relationship, her mother had a son named DL. Breasia and her brother were only 2 years apart and therefore were very close to one another. The defendant was involved in the lives of Breasia and DL, but not on a consistent basis. Recently, before July 10th, 2020, Aisha had discussions with the defendant, encouraging him to be more involved in his son's life. As a result, plans were made for the defendant to spend time with DL on July 9th, 2020. On July 9th, 2020, the defendant went to the children's grandmother's home to pick up DL. While there were discussions between the defendant, the children's grandmother, Breasia, DL, and their older brother, CS. During those discussions, it was DL's desire to have his sister, Breasia, come with him, and his older brother, CS, said he would like to come as well. The defendant approved Breasia to come along, but did not approve the older brother, CS, to come along. Although the children's grandmother did not give permission for Breasia to accompany DL during the visit with his father, Breasia did leave with DL and the defendant. When Aisha returned from work, she was informed of the events when the defendant picked up the children. She then gathered clothing for the children, which included pajamas for the evening and other clothes to change into, and then proceeded to the apartment where the defendant resided with his girlfriend, Andrea Culberson. When Aisha arrived at the apartment, Breasia came to the car to collect the clothing, and she was excited to see her mother and their dog, their family dog. After the defendant took the children into his care, they proceeded to the home of one of his friends. At that home, the children played video games and other games with the children in the home while the defendant visited with other adults at the residence. They then proceeded to the apartment located in the Jersey Meadows apartment complex in Davenport, which the defendant shared with his girlfriend of 6 years, Andrea. The apartment occupied by the defendant and Andrea was a one-bedroom apartment, which was accessed by a single exterior door that opened to a staircase entering into the open apartment located on the second floor of the building. The one bathroom in the apartment was located off the bedroom. Also within the bedroom were 2 closets, one used by Andrea and the other used by the defendant. While at the apartment, DL played video games in the living room area of the apartment, and Breasia played video games and interacted with Andrea while she worked remotely in the bedroom. The children were provided dinner, then showered and readied themselves for bed. The children did not put on pajamas provided by their mother for bed, but were each provided defendant's large white t-shirt size 4XL to wear to bed. The children were allowed to sleep in the bed in the bedroom, and the defendant and Andrea were going to sleep on the air mattress in the living room
Stop buffering.
area. Breasia fell asleep first, then Andrea, and then soon after DL and the defendant. At some point in the early hours, DL felt his sister Breasia kick him, and in a statement to police, remembers seeing her leave with the defendant. Subsequent to that, at 3 o'clock in the morning, Andrea awoke to use the bathroom. At that time, she noted the defendant and Breasia were not present in the apartment. She had not been told that the defendant left, nor that he had taken Breasia with him. She was very concerned about the situation and decided to stay up in the living room in the dark to wait for the defendant. She realized his phone was not charged, so Andrea placed it on a charger. At approximately 3:30 a.m., Andrea heard the defendant open the door to the apartment very quietly and proceeded up the stairs very quietly, as if not to awake anyone. When the defendant arrived, he did not have a conversation with Andrea. Even though she had tried to speak with him, he would not interact with her. While at the apartment, the defendant went into the bedroom and retrieved something from his closet, which he had exclusive use of, and Andrea was unable to see the object retrieved. The court finds that the defendant either retrieved the gun used to kill Breasia or another item to facilitate his murder of Breasia. The size of the revolver retrieved from the pond would have been easily concealed. Prior to the defendant leaving the apartment, Andrea looked out the window and saw Breasia in the large white t-shirt she had worn to bed next to the maroon Chevy Impala. When the defendant pulled away in the vehicle, Breasia was no longer there. The defense argues there is no one testifying they saw Breasia in the Impala. Although this is true, the court is relying on its common sense and experience that if Breasia did not go with the defendant, then she would have entered the apartment or knocked loudly to gain access to the apartment. Breasia was not familiar with this complex. If she was not with the defendant, she would have wanted to be with her brother and Andrea. The defendant then traveled to a quick shop on 53rd Street in Davenport. While at the quick shop, the defendant purchased $35 worth of gas, cigarettes, and a lighter utilizing a $100 bill. The evidence establishes the gasoline purchased was sufficient to fill the tank of the Chevy Impala he was operating. During this time at the quick shop, it is evident the defendant is ensuring that Breasia remains in the vehicle while he is inside the store. From the quick shop, the defendant then traveled to the pond located in Clinton, Iowa, which is south of the Kunow implement plant. This pond is located in the intersection of 218th Street and 270th Avenue. It is at this pond that the court finds the defendant willfully, deliberately, and with premeditation killed Breasia by shooting her 3 times. The defendant then, in the process of leaving the area, became stuck off the side of the road. He then walked to US 61 and flagged down a vehicle driven by Jared Brink. Brink then proceeded to drive the defendant back to the area where the Chevy Impala the defendant was operating was stuck off the roadway. Brink then removed the vehicle utilizing a chain. The defendant offered Brink $100 for his help, which Brink refused. These findings by the court are overwhelmingly supported by all the evidence provided by the state's witnesses, particularly the brave testimony provided by DL. And his statements to law enforcement. Additionally, the testimony of Brink offered through his discovery deposition and his statements made to police. All of this was further supported by the testimony and statements made by Aisha and Andrea. Their testimony and statements were corroborated by the investigative efforts of the Davenport Police Department and the FBI, except for the testimony of DL, stating that he saw his father shot Breasia. The court finds his testimony credible. His testimony is supported by the subsequent investigation by the Davenport Police Department and the FBI, and additionally by his videotaped interview with the police after the disappearance of his sister. This court finds it remarkable that an 8-year-old child is able to communicate with the police with such specificity to allow the Davenport Police Department to begin their investigation. DL explained to the officers he was on a dirt road with his father, and there was a hill which went down towards the water. Additionally, DL stated when he was with his father, the defendant explained he had earlier become stuck, and he was with some fishermen. They pushed him out, and he offered them $100. DL tried to explain the area he was with his father, which included seeing tractors, water, and a hill down to the water. It was not until later this statement is corroborated by subsequent discovery of Breasia's remains. The court finds beyond a reasonable doubt DL was present in the area while he was with the defendant.
Buffering.
FBI Special Agent James McMillan took soil samples in the area where Jared Brink pulled the defendant from the shoulder of the road. Those soil samples were compared to soil samples obtained from the undercarriage of the Chevy Impala operated by the defendant. FBI forensic geologist examiner Ian Sagadorn determined 3 of the samples taken from the area concentrated where the Chevy Impala would have been stuck were inclusive to those soil samples taken from the undercarriage. Of the Chevy Impala operated by the defendant. Brink came forward after the news of Breasia's remains were discovered, and there's no doubt in this court's mind whatsoever he identified the defendant as the operator of the Chevy Impala, which he removed from the shoulder of the road, and that he identified the vehicle removed from the shoulder of the road, that being one operated by the defendant. Brink identified a very distinct characteristic of the defendant's face, which was a mole on the right side of his face by his nose. The white aux cord located within the vehicle and the shorts worn by the defendant at the time he had made contact with him. All of this evidence proves beyond a reasonable doubt the defendant had Breasia Terrell within his control. He was at the site of her remains, and he was the only person who shot Breasia that early morning of July 10th, 2020. The defendant, after being pulled from the shoulder of the road by Brink near the pond located by Kuno Implement in Clinton County, Iowa, then returned to the apartment he shared with Andrea in Davenport around sunrise. When the defendant arrived at the apartment, Andrea was surprised to see the defendant in a different set of clothes. Andrea testified when she fell asleep, the defendant was wearing a white tank top and colorful shorts. When he arrived back at the apartment, he was in a white t-shirt and blue shorts. Upon his return, he took DL with him. Before he left with DL, Andrea insisted the defendant take his cell phone with him. Even during this time, no discussions were had that Breasia had disappeared. The defendant then traveled to Walmart located in Clinton, Iowa. At Walmart, his only purchase was 2 bottles of Clorox bleach. The defendant, on the way back to Davenport, stopped at the pond located at the intersection of 2018th Street and 270th Avenue in Clinton County. It is unclear whether the defendant may have stopped at this location on his way to the Clinton Walmart, but it's beyond reasonable doubt the defendant did stop there after making the purchase of bleach at the Walmart in Clinton. DL clearly described this area in his statements to the police and by his statements of his father wiping off a large knife with bleach. DL's testimony and statements regarding this portion of the activities of the defendant are clearly supported by all the investigative evidence presented by the state. Cell phone records of ping notifications of the defendant's cell phone are non-existent until DL places the battery back into the defendant's phone. The testimony from the various officers of the Davenport Police Department and special agents of the FBI were credible as to their findings of the cell phone being disabled or dead when the battery was placed back into it, and the pings were registered on the various cell towers. The fact that the phone was equipped with an auxiliary cord to charge the cell phone supports this finding that the defendant was taking actions to avoid his whereabouts, being traced by his cell phone pinging on cellular towers during his travels. The court finds DL's statement, testimony as to the smell of bleach while the defendant wiping off the large knife which the evidence indicates was the machete. Very credible.
A
During
false
purchase,
sense
and the
of
court
smell.
finds it reasonable that such substance was used at the time of wiping the knife and would have been used in the area in which Breasia's remains were recovered. DL's testimony and statements are further corroborated by the fact the officers investigating the case and saw what happened in the area of Walmart. It is only due to DL's statement that he placed the battery back in his father's phone to play a game and then took it out upon his father's return in the store. This information led to further investigation as to the defendant actually being in the Clinton Walmart and purchasing the bleach. At the time of DL's statements, there was no knowledge of purchase of bleach. Additionally, DL identified the knife as the machete in the exhibit shown by Detective Hannes. There was knowledge of such machete prior to discovery of machete in the defendant's RV. Although machete did not reveal DNA or fingerprints, it is clear to this court it had been wiped off because there were fibers within the serrated edge of the machete. Then again, after leaving the area of the pond, the defendant traveled into Davenport and traveled in the area of his motorhome in Credit Island. Clearly, he placed the machete, which had been in his trunk, into the motorhome. The defendant called Aisha at 8:08 a.m., telling her that he had just woken up and Breasia was missing. Although prior to this time, he had been driving all around Clinton County, and at that time of the call to Aisha, he would have just been entering Davenport as he was seen traveling south on Highway 61 at 7:52 a.m. He was then in the southwest area of Davenport and near Rockingham Road, near his home in Credit Island. He did not leave that area of southwest Davenport until approximately 8:26 a.m. During all of this time, there was a series of telephone calls and text messages between the defendant and Aisha. During these exchanges, the defendant had advised Aisha he was traveling to the Davenport Police Department to make the report of Breasia's disappearance. Aisha then left her place of employment at Checkers on East Locust Street in Davenport and headed to the police station. It was at this time Aisha was traveling west on Locust Street to the police station. She noticed the defendant heading east at a high rate of speed. She then turned around to follow the defendant and caused him to stop at the McDonald's at Eastern Avenue in Kimberly. Around this time, Aisha made contact with the Davenport Police Department and determined the defendant never appeared at the Davenport Police Department, and the request was made that she and the defendant proceed to the Jersey Meadow apartment complex. They then proceeded in different vehicles to the apartment complex and met with police officers who responded to the initial investigation of the disappearance of Breasia. Upon her arrival to the complex, Aisha was the first individual to meet with responding officer Craig Burkle. Officer Burkle advised both Aisha and the defendant he would like to search through the apartment to ensure Breasia was not hiding within the apartment. Immediately, the defendant stated she's not there and they had looked everywhere. The defendant took Officer Burkle up to the door of the apartment. When approaching the door to the apartment, the defendant knocked, which was odd since he occupied the apartment with Andrea. Andrea answered the door, was very hesitant to allow the officer in, and only allowed him in after it was confirmed the defendant consented to the officer searching the apartment. Officer Burkle then searched the apartment. Of course, Breasia was not located within the apartment, but upon Officer Burkle's return outside, the defendant was nowhere to be found. Subsequently, Officer Burkle called the defendant's cell phone at least 6 times within an hour's period and then texted the defendant. There was no response from the defendant until he called Officer Burkle upon his entering the police station at approximately 12 o'clock p.m. The defendant's whereabouts were unknown for a period of approximately 3 hours. Through cellular tower pings, it was determined the defendant had traveled to his sister's home on approximately 3 occasions, which is supported by cellular analysis. It is important to note that the defendant had changed his clothes from the early morning hours from the white tank top, blue and pink shorts, and gold shoes into a white t-shirt, blue shorts, and still gold shoes. And then upon his arrival at the police station, had different tennis shoes on, which were blue and white. Search warrants were executed for all of the vehicles, the apartment that the defendant shared with Andrea Culberson, and the home of the defendant's sister. At no time were the white tank top, pink and blue shorts, or gold shoes ever recovered at any location. They were nowhere to be found during the entirety of this investigation. Shortly after noon, the defendant was then interviewed by the Davenport Police Department. During this interview, the defendant was extremely evasive as to the location of the Chevy Impala. He was very evasive about his whereabouts. He stated at various times that he had been looking all over Davenport for Breasia, and that he had no knowledge of where she was at. He made no statement to the officer that he was with Breasia at 3:30 in the morning, and gave no information about the fact that he had traveled all the way to Clinton, Iowa with DL. He also indicated to the officer that he had traveled to his motorhome to get money in order to purchase gas. Court finds a statement by the defendant completely untruthful, as he would have had sufficient monies from the change he received back from his purchase at the Quick Shop. He had $100 to offer Brink, and most notably in Exhibit 6-16, the officers located.
Stop buffering. I have plenty to. It's plenty of.
Approximately $5,000 in $100 bills.
Stop buffering. Okay, I will try to.
In the search of the Chevy Camaro, which was operated.
I will try to change from my router to my phone and see if that helps. It will be a small glitch. One moment, please.
Defendant made during interview with the police was that he went to the Quick Shop. The court finds none of the statements that the defendant made during the interview to be truthful in any respect. The court finds beyond a reasonable doubt the defendant was the last person seen with Breasia. He had taken custody of her, had no authority to do so, and removed her from the apartment from which he had authority to care for her, with the specific intent to inflict a serious injury upon her, knowing that he did not have the consent or authority of Breasia or her mother to do so. And as a result of that removal, Breasia suffered death, which is clearly a serious injury. The court finds beyond a reasonable doubt that Breasia was shot by the defendant and that she died as a result of being shot. And the defendant did this act with malice aforethought, and the defendant acted willfully, deliberately, and premeditatedly with all the specific.
Jesus Christ. Sorry. Why?
Intent to kill Breasia. All this occurred on or about the 10th day of July, 2020, and the criminal activity began in Scott County, Iowa, and the defendant's criminal activity continued as he traveled into Clinton County, Iowa. Court finds beyond reasonable doubt that the remains located at the pond at the intersection of 2018 18th Street and 270th Avenue are those of Breasia as a result of the testimony of the forensic anthropologist, Dr. Heather Garvin, and the medical examiner, Dr. Kelly Cruz. Matthew Dean and David Baker were both inmates at the Clinton County Jail. While the defendant was being held pending trial in this matter, both of them credibly testified during the airing of news story concerning the disappearance of Breasia. The defendant made the statement, "They are never going to find her."
Not one.
Both of these witnesses are credible, specifically Matthew Dean, who was no longer being held on any criminal charges, and David Baker testified he was not receiving special treatment in regards to any pending criminal charges in exchange for his testimony. Therefore, neither of these individuals had anything to gain from their testimony.
Bullshit.
Specifically, David Baker
Bullshit.
testified when he heard the defendant make the statement, he took the statement to mean the defendant knew where Breasia was located.
I will
The
say
court
this
found every
until
witness who testified on
the day I
behalf
get
of the state to be
deleted from every
credible in their
platform.
testimony.
There's not
As
one
noted, the only
reason to
testimony the
switch
court did not
anywhere
find credible
with an ounce
was that of
of
DL,
credibility.
as to him being present in seeing the defendant shoot Breasia. The court's credibility findings are appropriate as statements were consistent between all the witnesses and were corroborated by the investigative efforts of the Davenport Police Department and the FBI and all other agencies. Again, it should be noted all of these investigative efforts would not have been fruitful had it not been for the information provided by DL. DL was instrumental in solving the murder and kidnapping of his sister Breasia. The court specifically finds the defendant was not savvy in any manner. The defendant did not account for the statements and testimony of DL and that of Jared Brink. The evidence provided by these two witnesses clearly and all the other witnesses undermined every effort which the defendant may have taken to be savvy or calculated in his actions to avoid being charged and prosecuted for the kidnapping and murder of Breasia. Ruling and verdict. Count 1, murder in the first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed murder in the first degree. The court finds beyond a reasonable doubt the defendant acted with malice aforethought and willfully and premeditatedly and with the specific intent to kill Breasia Terrell, shot her on July 10th of 2020. And as a result of being shot, Breasia Terrell died. Thus, the defendant is guilty of the crimes of murder in the first degree. Accordingly, the court, based on the testimony of the witnesses and review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of murder in the first degree in violation of Iowa Code Section 707.2, paren 1, paren B. Count 2, kidnapping first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed kidnapping first degree. The court finds beyond a reasonable doubt the defendant removed Breasia Terrell on July 10th, 2020 from the apartment in which he was caring for her with the specific purpose of inflicting serious injury upon Breasia Terrell. The defendant knew he did not have the consent or authority of Breasia Terrell to do so, and as a result of that removal, intentionally subjected Breasia Terrell to serious injury, that being death. Accordingly, the court, based on the testimony of the witnesses and a review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of kidnapping first degree in violation of Iowa Code Section 710.2. It is therefore ordered and adjudged and decreed that the defendant, Henry Earl Dinkins, is guilty of the offense of, under count 1, murder in the first degree in violation of Iowa Code Section 707.2, paren 1, paren B, and guilty under count 2, kidnapping first degree in violation of Iowa Code Section 710.2, as contained in the trial information filed by the state of Iowa. It is further ordered an informal pre-sentence investigation report shall be prepared by the 7th Judicial District Department of Correctional Services. The PSI shall be electronically filed by noon 3 days prior to the date of sentencing. It is further ordered sentencing in this matter is scheduled for October 11th at 1:30 in the afternoon. It is further ordered the defendant is being found guilty of forcible felony shall remain in the Scott County Jail pending sentencing without bond. Thank you.
I agree, Gigi. I'm not upset about the verdict. I am upset about the evidence we used. That, for me, is... I know everybody can cheer. I think verdict-wise, I said this a bunch of times. I believe he did it. But the evidence the judge used opens up for so many appellate issues. If Mr. Dinkins hires a good appellate lawyer, this might be overturned. And then you have double jeopardy. Or he might get a new trial and they have to do everything again. Or if it's an unforced error, then he might walk. There was, in my opinion, enough of circumstantial evidence, if presented correctly, to convict Mr. Dinkins. Okay, what's going to happen now? Well, apparently, sentencing will not be today. That will be later on. I will cover that too. And yeah, but I've said this from the beginning. Justice for Breasia. I don't see this as justice for Breasia. Might be a good decision, but the motivation, it's horrible. Yes, Dirk, the judge thought DL was a reliable witness. Not even Detective Pfeiffer believed DL. And he said that on the stand, under oath. So the judge deemed DL as completely truthful. Completely. He said that Mr. Dinkins going into his closet, that might have been a gun. He could have concealed a gun. Okay. I understand, James Lee. And this is the difference. But I simply have, let's go back to this. The court has adjourned for today. Let's go back to this. The court has adjourned for today. There will be no sentencing today. That will be on a later date. Okay, sentence on first-degree murder in Iowa. Yeah, but it still has to enter it into record. And there has to be victim impact statements and a lot of stuff, even if the sentencing is. So we still have kidnapping, murder. So we have to enter it officially into evidence. Yeah, I agree. Mr. Dinkins. And we covered that a week ago when I read his rap sheet. Mr. Dinkins is a through and through evil man. And if the Iowa justice system had done their job properly, after Mr. Dinkins violated his registry by being near kids, he violated it in 2003, 2004, and 2007. He still walked the streets. Yeah, I heard. That it was a bit surprising that they reached the verdict in the Whitmer trial, because they put in a lot of questions. And for you who doesn't know, the Whitmer trial is 3 guys being on trial for attempting to kidnap the governor in Michigan. And David over at MLS Law Show have covered it. And I would say that's entrapment by the FBI. FBI looked for people. FBI told people what to do, what to buy, where to go. And then 3 guys, okay. And then they charged the 3 guys, or 5 guys, or 6 guys, or whatever it was, as militia. And yeah, that's the feds. And I'm Swedish. We have our feds here too. Yeah, MG law, 100% entrapment. Yeah, here's the thing with the entrapment in the Michigan case. The judge, via the prosecution, denied the defense to use entrapment as a defense. Denied a proper defense. But we are here for this trial, this verdict. Again, do I believe he did it? Yes. Do I believe the prosecution did a good job? Absolutely not. Do I believe the judge motivations are good? Absolutely not. If you rely on DL and on prison snitches, you're a fool. Then you have the verdict and you try to find some evidence that supports it instead of the other way around, in my state. Peace, Pione. If the judge misstates evidence in his ruling statement, does that provide grounds for appeal? Yes, that's unforced error, in my opinion. I think that MG Law can, or David in the chat can provide you with better opinions. October 11th is the sentencing in this. Is judge talking now? What? No, not that one. I don't have a stream for that. I don't have a stream for that. Not even close. Corn Pope. The sun has had nothing to do with finding the body. Quad Cities news station. I just that stream for me has ended. The Quad News 8 channels. No. Oh, James Lee's fiancé rewinded. Okay. No, there was nothing in the kid's testimony that said where to find Breasia's body. And remember, DL also testified that he saw it happen and he saw his dad and Andrea do it. Which the prosecution itself said, no, that never happened. Because in the prosecution's case, Breasia was already gone when he picked up DL. So it couldn't, yeah. Yeah, in my opinion, verdict, I understand it. The motivation is horrible. Horrible. It opens up for appellate issues enough that there might, if there is an unforced error in the appellate court. Now, I do know appellate is for losers. I understand that. So they could go for a new trial before appeal, or they can go for direct appeal in Iowa. But there we are. There we are. Okay. I am equally... I'm not disappointed for my sake. I'm disappointed for Breasia. This, in my opinion, did not bring justice for Breasia. I'm disappointed in that. Because this verdict left so much appellate issues. Judge already made up his mind. The judge probably didn't even see the letter. He was informed that Mr. Dinkins wrote the letter, and then his clerk probably wrote, "We can't put anything into this because Mr. Dinkins, you have a lawyer. Everything must go through your lawyer." And they filed it. So my guess is that the judge never saw the letter in person. Yeah, I agree, Snivels. Not surprising outcome, just disappointed in the judge's reasoning. And for me, it leaves too much appeal issues. In my opinion, sun is shining in. In my opinion, had he based his verdict on the good circumstantial evidence, the phone records, the data, and then bring in Diaz's testimony only on the things that could be proven otherwise. Basing finding bleach based on DL's nose is horrible. That's not evidence. You need, if you don't test, this is the difference between a Swedish court and a US court, maybe. If there aren't, you can't rely on nose, human nose. You can't. Especially not from a witness that contradicts itself all the time. That bleach would have been tested for in Sweden. Mr. Dinkins was found guilty on both counts. Testimony is evidence, but the weight of that testimony has to be, the weight is high weight if it is collaborated by other evidence. Just saying I smell bleach without a test that backs it up brings it to an extremely low evidential value. I'm not there because I see too many appeal issues. Too many. Way too many. Just if you might have heard when I shouted out, it was when the judge said that the prison snitches was credible. There is not a single prison snitch on the globe that has any form of credibility, in my opinion. And Snivel says, I was with him until he went into the DL testimony. Yeah. And this is the difference. I understand you. You who think verdict was correct, I agree with the judge. And my standard is simply higher to go with that. And hopefully you don't get too mad at me for that. But this is just me maybe preparing you for that this might be overturned, even overturned with prejudice, so that double jeopardy. This is me preparing you for that. And then we will all be disappointed. Was his right to appeal waived by illegally contacting the judge during the trial through a letter? No. That's the simple answer. Oh, was there gifted memberships? Hold on, they don't show up in StreamYard. So I have to try to go in. Oh, Peace Peony, thank you for the... Wi-Fi. Okay, it seems like I have Wi-Fi issues. I apologize for that. Okay, there we go. Thank you, Peace Peony, for gifting 5 memberships. And thank you, Gigi, for gifting 1 membership. You who are new members, there are members-only content on my channel, and you also get access to my Discord, where you can continue debating the trials I'm covering. Mama Sorry says, seriously, now we need experts to explain how a pregnant person can smell something no one else does. Yeah, that was horrible. Okay. Now I have 2 different... I will set up a new... Hold on. Dave isn't on yet. Because I've heard both acquitted and hold on. Okay. I have dun, dun, dun. Yeah, I agree, Snivels. I thought someone said guilty earlier. Dave is on a plane to Texas, so I will set that stream up and redirect you to that one, and I will find the stream and we will go through it. Okay? Just a second so I can set that up. Dun, dun, dun. Live streams done. No, done. There. Okay, stream is set up. So, yeah. 69% of you was correct. That, 74%. It ended with guilty on both charges, so you are correct. Okay, so we have... okay. I have set up a stream for the Whitmer verdict. Again, thank you all for being here for this verdict. If you want, I will redirect you to the Whitmore verdict, and I will find the stream for it, and we will look at it so we can get all the facts straight. CCCTV judge stated everything DL said was verified through evidence except for him seeing Dinkins shoot Breasia, and he didn't accept that part of the testimony. Well, in my humble opinion, the judge was wrong. There was no evidence of bleach. There was no testing done for bleach anywhere. None. Time for the Whitmer. I will redirect you, and as soon as I find the stream, I will start that stream. So I will just redirect you over, and I'll be with you in a minute. He bought bleach at 7 in the morning, and then there was circumstantial evidence that, in my opinion, was there that there was time for Mr. Dinkins to pour bleach, to do all these things. But there was no testing. There was no testing of bleach. I'm sorry, lady. It was in both the prosecutions and the defense closing statements. But here we are. On this topic, we will return on October 11th, where we will listen in on the sentencing. And if anything comes from the defense before that, I will cover that too. But for now, I will redirect you to the Whitmer verdict. And I hope you all follow me there. Thank you for joining me. Don't be too mad at me. See it as a debate between respectfully, because we all think the guy did it. I'm not there regarding the evidence, and I think the judge opened up for too many appeal issues. That's my opinion. But I will see you over at the Whitmore stream in a couple of minutes. Thank you so much again for joining me here, and I'll see you in a bit.